न मुसलमान बनेगा, इंसान की औलाद है, इंसान बनेगा. Madam, this present bill covers importantly two areas of the WAQF. One, manage religious affairs of WAQF board. One of the arena is to manage, control, supervision of the religious aspects of the Muslim. Two, providing power to the state government to decide the disputes in respect of the WAQF property, including land and building. Article 26 of the Constitution of India provides that, subject to public order, morality and health, every religious denominations or any section thereof shall have the right, A, to establish and maintain institution for religious and charitable purpose, B, to manage its own affairs in matter of religion, C, to own and acquire movable and immovable property, D, to administer such property in accordance to such law. Madam, the WAQF is an institution for religious and charitable purpose. The Muslim have constitutional right to manage its own affairs in the matter of religion because WAQF property belongs to Allah. They have also the right to administer such property. The purpose of the bill is a clear breach of the right of the Muslims to perform their religion duty, to manage their religious affairs, and therefore completely in violation of Article 26 of the Constitution of India. The bill hits basic structure of the Constitution. Madam, under Article 246, sub-Article 1, the Parliament has an exclusive power to legislate a law under 7th schedule of list 1, and under Article 246, sub-Article 3, the state is having the power, state legislature is having the power to legislate the law, exclusive power. Sir, excuse me, sir. That is to say, land comes under list 2, under entry 18 of the state lists. Lands and buildings vested in or in the possession of the state comes under entry 35 of the list 2 of the state list. In the proposed WAQF bill, the Parliament has no power to legislate any law in respect of the land and building vested in possession of the state in respect of the WAQF property, because the state is only having power to legislate such law. Therefore, the Parliament is now encroaching upon the power of the state legislation in deciding the question of the land and building of the WAQF. Thus, it is completely unconstitutional and divorce the Article 246, sub-Article 3 of the Constitution of India. This is also hits the basic structure of the Constitution. By exercising any power under list 1 or list 3, state legislative power under list 2 cannot be encroached. There is a difference between a WAQF recognized by the Muslim law and religious endowment and recognized by Hindu law on the one hand and public charitable trust as contemplated by the English law on the other. The question has been considered by the Privy Council in Vidya Bharuti Tirtha versus Bulsami Ayar, long before. Mr. Amir Ali, who delivered the judgment of the board, observed that it is to be remembered that a trust in the sense in which the expression is used in English law, when the gift is directly to an idol or a temple, the season to complete the gift is necessarily effected by human agency. Called by whatever name, he is only the manager or custodian of the idol or the institution. In no case is the property conveyed to or vested in him. Similarly, that is a basic difference. The Honorable Minister, he was speaking about the Hindu trust. The Muslim law relating to trust differs fundamentally from the English law. Hindu trust follows the English law. Muslim law doesn't follow English law. That is a basic difference. Mr. Amir Ali said the Mohammedan law owes its origin to a rule laid down by the Prophet of Islam and means the tying up of a property in the ownership of God the Almighty and the devotion of the prophets for the benefit of the human beings. As a result of the creation of a WAQF, the rights of the WAQF is extinguished and the ownership is transferred to the Almighty. It is religious. If it is religious, comes within the ambit and scope of Article 26 of the Constitution. The manager of the WAQF is the Mutawalli, the governor, superintendent, curator. But in that capacity, he has no right in the property belonging to the WAQF. The property is not vested in him and he is not a trustee in the legal sense. Therefore, there is no doubt that the WAQF to which the Act applies is essentially features different from the trust as is known to English law. In Sarabanu versus Union of India, 2017, volume 9, SCC, page 1, the Constitution bench held that any legal provision should be made with the application of known principles of law. If any decision is taken without supporting principles of rule of law, it becomes unpredictable and such a decision is antithesis of a decision taken in accordance with the rule of law. This proposed bill is just contrary to the well-settled principles of law which is established in the country by the judgments have been pronounced not only by the Privy Council, by the Supreme Court of India also. Madam, the various provisions of the WAQF Amendment Bill 2024 is manifestly arbitrary and therefore cannot be passed by the Parliament itself. The WAQF system in Islamic tradition stands as a testament to the enduring values of charity, community, welfare, spiritual dedication rooted in the principles of Sadaqat Jariyah. WAQF in India, WAQF properties form the backbone of the Muslim communities, social, cultural and religious life, playing a pivotal role in maintaining their collective identity. This endowment sustains mosques, madrasas and cemeteries while providing essential resources to marginalized section of society, especially in an environment where minority communities often struggle for equitable access to public purposes. This is not there. Equality, equitable access is not there in case of the Muslim. That is the reason we are opposing. Over the years, excessive government oversight has raised concerns about the erosion of the autonomy and sanctity of WAQF, which under Islamic law is intended to function independently to serve its religious and charitable purposes. At the heart of the WAQF system administration lies the State WAQF Board, while act as custodian of WAQF properties, ensuring their proper management and alignment with the purposes by Islamic law. These boards have consistently worked to protect WAQF properties from the mismanagement. Madam, the WAQF was centrally first introduced in 1953. Mr. Riju, the Honorable Minister, has said, thereafter so many acts, then 1995 Act has come, Amendment 2013, now it is coming. Now by introducing Clause 2, the title of the Act has been amended, Unified WAQF Management, Empowerment, Efficiency and Development. There is no rational basis to make such amendment of the title of the Act. Every Act is intended to make the Act more efficient and development purposes. As for example, the Companies Act was enacted in 1956, thereafter re-enacted in 2013. The Act was brought to regulate the management, empowerment, efficiency and development of the control of the companies. The WAQF Act 1995 had various provisions for management, empowerment, efficiency and development. Therefore, the said proposed amendment to the title is wholly unwarranted. The title, which is being used nearly for 75 years, has no necessity to be amended unless the government wants to have the satisfaction that something new has been done. The proposed amendment to the WAQF Act, which includes a tacit attempt to alter or dilute the historical and religious significance of the term WAQF, is deeply concerning and warrants strong objection. The term WAQF is not merely legal or administrative level. It is a sacred concept deeply rooted in Islamic tradition and jurisprudence. Why you are taking away this? Madam,
they want to interfere in
please, Sogadda, please. The historical development of WAQF legislation in India, from the Bengal WAQF Act 1934, Uttar Pradesh Muslim WAQF Act 1960, the WAQF Act 1954, and the subsequent unification under the WAQF Act of 1995 has always retained the sanctity of the term. These laws, while designed to provide statutory governance, have consistently respected the essence of WAQF as a concept grounded in Islamic law. Madam, insertion of clause 2A. Insertion of clause 2A tantamount to nullify all earlier judgments, degree and orders of any court in respect of the WAQF and the trust. This attempt is basically taking away the rights of the Muslim, which they have accrued. Any attempt to nullify the Supreme Court judgment by legislative process is illegal and unconstitutional. Clause 3 Roman 9 of the proposed bill that said various sects and subsects have been created. This attempt to create subsect without having any rational object is not a good sign for any religion, caste or creed. If the constitutional provisions empowers the parliament to create caste, subcaste or subclass, only then the parliament can do so. Like the scheduled caste created inside Hindus, but the constitutional provision does not empower the parliament under the guise of the WAQF Amendment Bill 2024, create Aga Khani WAQF, Bora WAQF, etc. The intention to legislate such kind of classification of WAQF board based on subsects, the ruling party in the government is having evil intention. If the title speaks about unification, creation of various WAQF board on the basis of subsect itself creates a de-unification between the sects and subsects of the Muslims. Madam, clause 3FA of the said proposed bill defines government organization including municipalities and panchayat and autonomous bodies of the state and central government to a part 9A of the constitution. Under the scheme of part 9A, the municipalities and the panchayats are self-government and autonomous bodies. How the properties of the self-government bodies can be treated as a government properties, madam? In a constitutional provision it has made it. By this law, panchayat and municipality has been described as a government properties. It is not a government properties, local self-government bodies. Therefore, there is a distinction. Therefore, this provision is bad. Madam, introduction of definition of the government property seems to be mischievous. Why WAQF will be allowed to define government property? This is an attempt to legalize illegal occupation or WAQF property by government organizations. Another sin is there. In our JPC, we have said repeatedly, give us the data where the government has occupied the property. Nothing is there. And in Rajasthan, it is a case, extreme cases. 80% of the property of the Rajasthan, WAQF property has been occupied by the Rajasthan government itself. Practicing Islam for at least 5 years is a precondition for making WAQF is thoroughly unreasonable, irrational and manifest arbitrary. Under the scheme of the Constitution of India, no person can be compelled to practice his own religion. If no person can be compelled to practice his own religion, then such persons cannot be debarred either to offer his property to God or whether he is Hindu or Muslim or any other religion. Practicing religion means day-to-day performance of his religious duty. In a secular democratic country like us, no one can compel to perform any religious duty. Even such a provision cannot be made either in the Constitution or in any other statute. No mandatory provision can be made for practicing Islam for at least 5 years for making WAQF. Even if I discharge my religious duty on my own at any place, I cannot be compelled to speak whether I am performing religious duty or not performing the same. Who is anyone can ask me whether I am performing religious duty or non-religious duty? Is it not a violation of a constitutional right? What the Constitution has given you the power to say, to ask me the question, I am discharging religious duty or not discharging the religious duty? A man can believe in performance of religious duty at any point of time of his life, any point of time, before death even. Performing of a religious duty cannot be the basis belonging to that religion. Even in a Hindu mandir which is governed by an act, like Puri Jagannath Temple or Kashi Vishwanath Temple, there is no such provision that any person practicing Hindu for at least 5 years and then only can donate anything to the deity. Madam, I can't donate. If I want to donate, it's my choice. How my choice can be controlled? I can donate to Hindu mandir. I donate to everywhere. I donate in Hindu mandir. I donate in Muslim property. I donate in the Christian property. I donate in the Buddhist property. I donate everywhere. I donate beggars. I donate everywhere. How can you control this act? How can I control? By reason of insertion of this clause, no other person of a religion can make over any property to WAQF. The proposed amendment is thoroughly misconceived, arbitrary, irrational, and therefore violates Article 14 of the Constitution of India. Under Clause 3, Roman 9b, existing Clause CR1 has been omitted. That means WAQF by user is being taken away. WAQF by user is a long-standing practice of Muslims. In our country, WAQF by user is a very common practice, and decades after decades, rather time immemorial. WAQF by user is a practice. The concept of WAQF by user was recognized in our country in the case of courts of words for the property of Magdam Hassan Baksa versus Illahi Baksa and others, 1912, SCC online, page 45. Madam, the Honorable Apex Court in the matter of Sayyid Muhammad Salih Labbai, dead by LR and others versus Muhammad Hanifa versus LR and others, 1976, 4 SCC 780. In paragraph 34, 36 and paragraph 39, categorically accepted this WAQF by user. The necessary in case of prayers offered in congregation. A single Muslim can also offer his prayers with or without an imam, but if prayer is in a congregation of a Jannat are offered only behind an imam who leads the prayers. And Islam is an extremely modern and liberal religion. There is no question of any person being denied admission in a mosque for the purpose of offering prayers, and that is why the law is so strict that the moment a person is allowed to offer his prayers in a mosque, the mosque becomes dedicated to the public, and therefore it's a WAQF property. Therefore it is a WAQF property. Finally, it is not necessary for the dedication of public mosque. Now, Madam, in that judgment it has said, so that when a person erects a building with the object of dedicating it as a mosque and permits people to offer prayers therein without declaring that he has constituted it into a mosque and prayers are offered, there bil jammat, the mosque becomes irrevocably dedicated. It is dedicated. Madam, I just give you one instance. In the Raishina village, where the residence of the President of India is there. It was a long back, it's a big village. In the big village, there are so many Muslims are there. One Hindu dedicated his property for offer their namaz. And that is the property, that is the mosque is in front of the parliament. In the front of the parliament. Who has not come here? All. Abdul Kalam Azad. So all important political leaders, including Bhutto, and the Imam of that is sitting here as one of our colleagues, member of parliament. If prayers are offered once in a mosque, it is sufficient to constitute a good dedication. Dedication has been clearly said. Paragraph 39 of the judgment, that the founder must declare his intention to dedicate a property for the purpose of mosque. No particular form of declaration is necessary. The declaration can be presumed from the conduct of the founder, either express or implied. If this is the principle of law, is long-standing in our country, how can you say today you have to register WAQF by user? You have to give a declaration. I don't need to. Therefore, you are trying to buy this bill. You are trying to take away the basic reason of all the judgments of the Supreme Court. This is not correct and this is bad. Madam, neither a document nor express words are essential for dedication of religious or public purpose in our country. Such dedication may be implied for user permitted for public and religious purposes for sufficient length of time. The conduct of those properties is presumed to be dedicated to for religious. It has been said by Sri B.K. Mukherjee on Hindu law. Sri B.K. Mukherjee on Hindu law of religious and charitable. I do not think that anyone in India is here now. Today, in India, there is anyone who understands Hindu law better than the B.K. Mukherjee. No one. He has said so in his book. Anyway, new concepts, smart mans have come, like a smartphone. Therefore, everything is being done. In the case of M. Siddiqui, through Elas versus Mahanath Suresh Das, 2021 SCC page 1, it has expressly said WAQF by user. Our jurisprudence recognizes the principles of WAQF by user, even absent an express deed of dedication. This is being taken away. Now, long judgment I will not read. This is being taken away by this. Therefore, it hits the basic things. Clause 3, subclause 5 of the said proposed bill. The verbal declaration of WAQF has been taken away. This is contrary to the history of creating WAQF by any individual. Several properties are dedicated as WAQF by a good number of persons to be made as WAQF property. Madam, the deletion of the word either verbally or violates the right of the Muslim as protected under Article 25 and 26 of the Constitution. Therefore, it hits the basic structure of the Constitution. In Commissioner of Police versus Acharya Jagadish Abbuddhota 2004-12 SCC 770, it comes from our state. When CPM was in a power, they killed Ananda Margis. In that case, this judgment has come. The protection guaranteed under Article 25 and 26 of the Constitution is not confined to matters of doctrine of belief, but extends to act done in purpose of religion, and therefore contains a guarantee for rituals, observances, ceremonies, and mode of worship which are essential or integral part of religion. What is WAQF then? It's an integral part of the religion. Madam, essential part of religion means the core beliefs upon which a religion is founded. Core belief of the Muslim is that Allah is there. I am dedicated my property to the Allah. Therefore, it's a WAQF property. It is upon the consensus essential power practice that the superstructure of religion is built, without which religion will be no religion. Madam, nobody can say that essential part or practice of one's religion has changed from a particular date or by an event. The proposed amendment clause 3 proceeds with the assumption that WAQF are riddled with the issues of mismanagement. It appears that primary basis of the assumption, very important, the very primary basis of the assumption is the quantum of pending litigation surrounding WAQF. If the basis of identifying body as mismanaged in the amount of litigation that is pending against in this cannot be a rational basis of determining the standard of management of a body. In fact, the Honorable High Court of Delhi in the case of Union of India, Kiran Manua, they has given the details of the pending cases. If pending cases are the ground for bringing the legislation, now I tell you the figure, statistics. In the pending civil cases in Supreme Court, 64,687. Pending criminal cases in Supreme Court, 18,235. Total pending cases, 82,922. And in WAQF, all over India, 14 to 15,000 cases are pending. If it cannot be said to be a basis. Madam, Section 3A, the clause creation of Clause 4, Section 3B, insertion of section that mandates that every WAQF, prior to the commencement of the shall file the details of the WAQF property dedicated to WAQF. I have already dealt with that. Madam, the WAQF board under its main statute has declared a property to be WAQF in the case that the government has to challenge the same before the appropriate court of law. Oh, sorry. Madam, this is a very important, sorry, I have missed it. Now the property, government property, according to minister, the state government officer above the district magistrate will decide the issue. How it can be? How the state can be judge of its own cause? State will decide, this is my property and it will be binding. And the problem is this, the moment it will be claimed, it will not be treated as a WAQF property. Madam, title of the land only can be decided by the civil court, not by anybody. And this title, this land, the power which has been given to decide the land, whether it's a government land or not, that is covered by the state list under entry 18 and entry 35. That is the list 2 of the 7th schedule. Parliament has no power to legislate law in respect of that. If the WAQF board under its main statute has declared a property to be WAQF, in this case the government has to challenge the same before the appropriate court of law. By amending this law, this cannot be done. A person cannot be judge of his own cause. It has to be gone to the civil court. It is well-known principles. Everyone knows about it, that it is with a dispute on the civil law and is there. Who will decide? It will be decided by the civil court. The proviso itself indicates a predetermined mind of the government. Then the WAQF board itself is a statutory body. 3C4. If there is any wrong writing in the records of the WAQF board, that can be challenged by the government in accordance with law. The government cannot direct the WAQF board to make the correction. This itself is hit by the doctrine of dictation. Madam, apart from the survey, there are currently the Honorable Supreme Court time and again reiterated. Survey records, they are mostly relying. Madam, the Honorable Supreme Court time and again reiterated that revenue records are not documents of title and they do not vest the right of ownership as a property to the individual named in the land record. References, so many references are there. I am not, this is an elementary thing. Any law student also know this branch of law. Unfortunately, this has not been taken care of by the central government. Clause 5E, the proposed amendment amounts to create subclause among the Muslims for the purpose of giving birth to give this dispute. Clause 9 of the proposed bill provides to clause 9 is totally unacceptable and it provides 2 members appointed under the subsection shall be non-Muslim. The exclusion of Muslim, the exclusion of Muslim community persons from holding the post of 2 members in the WAQF board is hit by Article 14 of the Constitution of India, which provides equal opportunity to everyone. In the case of Hindu temples, the non-inclusion of Hindus cannot be imagined. We can't imagine. For example, under Section 6, subsection 2(1) of Uttar Pradesh Kashi Vishwanath Temple Act, it has been specifically mentioned that there are 3 eminent Hindu scholars well versed in the Hindu. A line has been set, a point has been taken. You see, these are the state law, but it is a central law. Law means within the ambit of Article 246 of the Constitution of India. Law doesn't mean beyond that 246. If a law is within the Article 246 of India, there cannot be discrimination between a state law and central law. This is kind of unthinkable stand has been taken. I cannot think about this. After long 44 years practice, I can't think. No, it's a state law. It cannot be compared with the central law. What is that? Law is having its own force. Read Article 13 of the Constitution of India also. What is law? Madam, Clause 11 of the proposed bill seeking amendment of Section 14. That is, amendment of original act suffers from same illegalities. Clause 14 of the proposed bill, whereby Section 20A of the original act, that is, removal of the chairperson by vote of no confidence, has been deleted. Such deletion is also improper, illegal, because if the chairperson does not enjoy the confidence of the other members, how can he sit there? It's a question of democracy. If the chairperson does not enjoy, madam, can you sit there if you don't enjoy the majority's confidence? If you cannot enjoy the majority's confidence, you have to leave. That is the democratic setup in our country. Madam, amendment of section 36 subsection 3 is effectively taking away the power of the WAQF board. Regarding receiving of registration of WAQF, and such amendment has been empowered the central government in an indirect manner to control everything. All powers have been taken. Why you are not making it the honorable minister? The minister of minorities will decide everything. He will be the supreme. Nothing is required. Finished. You can do it. Clause 20 of the bill amending of section 40 of the original act. If section 40 is deleted, madam, the WAQF board power itself will be teethless doll. If section 40 is amended and section 40 is taken away, the WAQF board will be a teethless doll only. If section 40, then there is no necessity to keep the WAQF board itself. Do not keep it. Keep the power with the minister of the central government. Minister will decide what is the necessity of the WAQF board. Everything will be done by him. Because the power to regulate and statutory WAQF board. This is complete. Madam, I will take some time, please. Complete reason I am reading very fast. I am going very fast. WAQF board. The proposed amendment bill under clause 21 seeking amendment of section 46 of the original act once again empowers the central government to make regulations with respect to so and so. Therefore, state power has been taken away. Does it not violate the federal structure of this country? Every power of the state government has been taken away. Only central will do it. That cannot be. It violates the fundamental character of the Constitution. Clause 22, amendment section 47 of the Act. The proposed amendment empowers Central to call for the audit of any WAQF board by the CAG. How the CAG can make an audit? CAG can make an audit in a case of consolidated fund. CAG can make an audit in a consolidated fund under the Constitution. How CAG can make an audit beyond the consolidated fund? This is absolutely illegal and improper. Madam, section 50, under the existing provision of the WAQF board, then comes section 83. By the proposed amendment, the members of the tribunal have been reduced to 2 and 1 person having knowledge of Muslim law. This has been done, it has been amended. Now the tribunal to order is tribunal to High Court. Tribunal to High Court under appeal. Now it is a statutory appeal. There is no provision for condonation of delay if there is any delay is done. If a direct is a statutory appeal, you have not given any power to grant any interim relief to the persons. How can be an adequate remedy? Earlier it was there. One could have gone on Article 226 of the Constitution for a judicial review. And High Court is having the power to condone delay and also to pass an interim order. This power you have also taken away. Therefore, this provision is not an adequate remedy so far the WAQF property is concerned. Madam, please. Madam, the High Court has not given any power. Madam, 107 and 108. I am going very fast. I am getting very fast. I am not taking even the water even. The proposed amendment has an effect on the decision to replace the survey commissioner. Then the under clause proposed section 107 of the act is deleted and thereby non-applicability of the limitation act. That is divorce. How the limitation act will be applied? If the limitation act will apply, so many disputes will come. This is the intention of the government. Open, sab khulo abhi khul do rasta. इंडिया में चला लगा दो, हिंदू मुस्लिम लगा दो, यही तो इंटेंशन है उन लोग का. क्या होगा? This is not correct. This is completely bad. The proposed WAQF proposes significant. In Hemant Wajid sir has also criticized the concept of adverse possession as unjust, urging reforms to protect rightful property. Therefore, this is a clear attempt. This is a clear attempt on the part of the bill to curtail the right of the Muslims in our country. ये ठीक नहीं है. मैडम, हिंदू या मुस्लिम का हाथ मत छेड़िए. अपनी कुर्सी के लिए जज्बात को मत छेड़िए एक जंग मिलजुल कर गरीबी के खिलाफ. दोस्त मेरे मजामी लगभग में मत छेड़िए. मैडम, हम अपनी जान